being amended pursuant to Section 5 of this bill. In fact, one has to wonder, why is it that in a bill which talks about judicial and legal provisions, why will in such a bill be amendment to the Information and Communication Technologies Act? Is it because of the timing? Are we being called upon to debate and vote an amendment because there's been certain texts and pictures circulating on Facebook, on the internet? Anyway, in his summing up, the Attorney General, I'm sure, will address the very serious concerns I have about the proposed amendment to the Information and Communication Technologies Act. First of all, Article 1 of our Constitution, Madam Speaker, provides that Mauritius shall be a sovereign democratic state which shall be known as the Republic of Mauritius. In my humble opinion, the proposed amendment violates Section 1 because it is not in accordance with what is expected in a democratic state. Article 3A of our Constitution, under the heading Fundamental Rights and Freedoms of Individual, provides, it is hereby recognized and declared that in Mauritius there have existed and shall continue to exist without discrimination by reasons of race, place of origin, political opinion, color, creed, but subject to the respect for the rights and freedom of others. Each of the following human rights and fundamental freedoms: A, B, freedom of conscience, of expression, of assembly and association, and freedom to establish school. Again, in my humble opinion, Madam Speaker, what we are proposing to amend violate Article 3A of the Constitution, the freedom of expression. Article 12.1 of our Constitution, under the heading Protection of Freedom and Expression, provides that, and I quote, except with his own consent, no person shall be hindered in the enjoyment of expression, that is to say, freedom to hold opinions and to receive and impart ideas and information without interference, and freedom from interference with his correspondent. It is, in my humble submission, a violation of the fundamental human rights of a Mauritian to freely hold opinion and receive and impart idea. I concede, Madam Speaker, that Article 12, subsection 2, provides that this freedom of expression is not an absolute right. We can, for example, enact a law for the purpose of protecting the reputation, rights, or freedom of other persons, or their private lives, or persons concerned in legal proceedings. We agree, Madam Speaker, that we have to protect the reputation of others. We have to protect the rights of others. We have to protect the privacy of others. But Section 46 of the ICT Act, as currently drafted, already provide the necessary protection of law. And may I remind the House that it is a minister issued from the MMN ranks that presented the ICTA bill back in 2001. And therefore, it was very important then and now to the MMM and for everybody, I hope, to protect, to have a balance between freedom of expression and the right to privacy, the right not to be morally harassed or unduly defamed by someone using the internet. We need to strike that balance. But what we have in this bill today, Madam Speaker, goes beyond that, what is necessary to protect. We are criminalizing. We are making it an offense today to use a telecommunication device to cause annoyance, humiliation, inconvenience to someone else. As the law correctly stands, if you use a communication device to cause distress or anxiety, it is a criminal offense. We agree with that. But here we're not talking about distress and anxiety, we're talking about annoyance. You send an SMS, you make a point which annoys someone else, it's a criminal offense, and now it's going to be punishable by 10 years imprisonment. You send a post on your Facebook, it causes an inconvenience, again, 10-year imprisonment. How can that be justified in a democratic state? We're talking about 10 years imprisonment, Madam Speaker. We live in a democratic state. We may not agree with what someone else may say. We always quarrel. We quarrel with family. We quarrel with our friends. But we cannot prevent someone from expressing his thoughts just because we don't agree with it. We cannot shut someone's mouth and put him to jail because what he's saying is causing us annoyance, is causing us inconvenience. And let's take my example, Madam Speaker. Time and time again, I go on social media and criticize the government. I'm sure each time I criticize the government, I'm causing them annoyance, I'm annoying them, I'm causing them inconvenience. But I'm a criminal because I do that? Am I going to be sent 10 years in imprisonment, 10 years in jail, just because I am criticizing and causing annoyance to the government and ministers and their cronies and friends and nepotists and others? And family members or us? This is a very serious and dangerous amendment that we're proposing. We're not talking about distress. We're not talking about moral harassment. We're not talking about saying defamatory words, fraudulent words. We're talking about simply saying the truth and hurting people's feelings, causing them inconvenience, annoying them. And even then, it's not an offense to cause them an annoyance. It's an offense if we say something which is likely to cause them annoyance, likely to cause them inconvenience. Whether actually, as politicians with crocodile skin, they were not affected or not, this is immaterial. It's an objective test. Is it likely to cause them annoyance? Is it likely to cause them inconvenience? I respectfully submit, Madam Speaker, this is anti-constitutional. Now, this example, this proposed amendment, will not affect only politicians, will not affect only those who criticize the government. It will affect every single Mauritian, especially the young ones, because it is the young ones who every day goes on Facebook, goes on Twitter, send SMS. I know of a case, Madam Speaker, very unfortunate case. There was a young chap in my constituency. He fancied a girl. In the good old days, we would go, tell the girls that we like her, and she will put us away, and that will be the end of the matter. We'll try again. She will again push her, and that will be the end of the matter. There's no offense because, we're all hopeless romantics, but that's so good for us. But this young guy, what he did was, he went on to send SMS to this girl, declaring his love for this girl. And the girl didn't say anything. The father found these SMS. The father took the girl and went to the police station and put a declaration against the boy. The boy was arrested. He confessed. He said, yes, I'm in love with this girl. Yes, I sent these SMS to her. And you know what happened, Madam Speaker? Later on, this girl had 18-year-old. She went to court and said, I don't want to go ahead with this case. The file was sent to DPP's office, and the DPP said, because he had confessed to a crime, he needed to be prosecuted, and he was sentenced to 15 counts of 15,000 rupees. 15 counts. Now, in that case, this boy had used swear words, juron, insult. So it was already an offense. But imagine this boy, instead of saying foul language, he was just declaring his love and annoying and sending so many SMS to this girl, was causing her to be annoyed or inconvenienced because her parents found out about it. This poor guy would be sent 10 years in jail now. This is how dangerous this law is. I was talking to a friend earlier, and he was telling me, what if you have a friend, a colleague from work, who sends you an SMS at 11 o'clock at night? Your wife finds out about it, or your husband finds out about it, and queries you, and you just go, oh no, and follows her. She's crazy. I don't know why she sent me these SMS. Next day, the wife or the husband goes to the police, take this SMS and say, there is a girl who is causing trouble to my husband. She's causing annoyance to my husband. She's causing inconvenience to my husband. 10 years imprisonment. This is what this law says. This is what this law says. We're smiling, but, many people, it can happen to many people in this house. Madam Speaker, Madam Speaker, I'm not talking about, as I said, I'm not talking about defamation. There's already the law who protects people against defamation. If someone goes and posts a defamatory statement on Facebook, Twitter, or wherever, you can prosecute him. But if someone causes you inconvenience, the remedy is to sue that person for damages. If you think that through whatever he said, you've caused inconvenience, you've been annoyed, and you suffered damages, you go and sue him or her in court. Civil matter. You don't take that person, handcuff him, and send him to jail. Now, forget about defamation. Let's take the case of insult. If today, Madam Speaker, you insult a person, your neighbor, or someone in the street, or a friend, you insult that person. You can be arrested and you can have a fine. But now, if instead of insulting that person, you send him or her an SMS, or you do a post on Facebook, it's no longer a fine. It is 10 years imprisonment. So because of the form of communication, from speech, there is one penalty. From saying the same thing, writing it down, tapping it down on social media, the penalty is tenfold. It's 10 years imprisonment. So is that fair? Is that democratic? Is that not against the rule of proportionality? Aren't we discriminating between the form of communication? Madam Speaker, I'm very concerned about this law because the temptation of abuse is there. When the threshold for criminalizing what you say is so low, everybody is in danger. When it is so easy to arrest someone because he has written something which has caused you annoyance, caused you inconvenience, then there's a high risk of this provision being misused by the government, by any government for that matter. And we know the track record of different governments who have come, unfortunately. We know the track record of people who have been arrested, handcuffed, humiliated, only to be released. Turiak wrote a whole book about these provisional charges. Now, I'm just saying a fact. I'm just saying a fact. These people were handcuffed, were humiliated, cases, provisional charges were lodged against them. Now, on such a case, you know how many people, not only politicians, how easy it would be for someone who doesn't like another person to go to the police and say, go and arrest that person because he sent me an email which is causing me annoyance, which is causing me inconvenience. And really, this will not hold the constitutionality test, Madam Speaker. And you're laughing, I can tell you my example. I can testify what happened to me. During the campaign, the municipal council campaign, when we were assaulted by the MSM activists, by the husband of Honorable Jadoo, I set a post. I put a post. Listen to that. I put a post on my Facebook explaining what happened on that day. And you know what happened? The police came and took me. And I had to go to the cybercrime because Mrs. Jadoo had given a statement against me. And I had to show that I was not lying. And in fact, the DPP is prosecuting her husband and activists of the MSM. But still, I was called under warning. My statement was taken under warning because an honorable member, former minister, had stated that Mr. Uteem wrote something in his Facebook. So he used a telecommunication device, which is causing me anxiety, distress. Now, what I did was true. I was let off. But I surely caused her annoyance. I'm sure that my post caused her inconvenience. So with this new law, today I would not be here. Maybe I would be behind bars if that law was applicable. So that is how dangerous we're talking here, how dangerous this law is. If you say something which causes annoyance, which causes inconvenience, you can be sent for jail for 10 years. And Madam Speaker, I'm not the only one who thinks that this is contrary to the Constitution. There has been a case in India the case of Srila Singhal versus Union of India. It's a decision of the Indian Supreme Court, and that was, it's 122 page long. That was delivered on 24th March of 2015. In India, there is a law comparable to our ICT Act, which is called Information Technology Act. And there is a section, section 66A, which is similar to our section 46, and which prohibits the sending of information of grossly offensive and menacing nature. And it is widely reported in the press, namely in the Hindustan Times of 2015, that this section had been misused by the police to arrest persons for posting critical comments about social and political issues, about political leaders on social media. And most of the arrests were for posting controversial remarks or photos, and for sharing, commenting on, or liking such posts. Does that sound familiar? People being arrested for sharing posts, for sharing pictures, for sending and liking posts. Madam Speaker, in this 122 page long, well-reasoned Supreme Court judgment, the court struck out Section 66A of the Information Technology Act 2000 being violative of Article 19(1)A of the Indian Constitution, which provides that all citizens shall have the right to freedom of speech and expression. Article 19(1) of the Indian Constitution is very similar to our Article 3 and Article 12 of our Constitution. Both guarantees the right of freedom of speech and expression. The whole judgment makes excellent reading, but I will cite only 3 quotations. First, citing US authorities, this is what the learned judges of the Indian Supreme Court said. Fear of injury, fear of serious injury cannot alone justify suppression of free speech and assembly. Men feared witches and burned women. To justify suppression of free speech, there must be reasonable ground to fear that serious evil will result if free speech is practiced. Another part, it is clear that Section 66A arbitrarily, excessively, and disproportionately invades the right of free speech and upsets the balance between such right and the reasonable restrictions that may be imposed on such rights. Such is the reach of this section, and if it is to withstand the test of constitutionality, the chilling effect on free speech would be total. Madam Speaker, we like to follow India. We like to call ourselves Chota Bharat. Let's follow what India is saying. You cannot oppress freedom of expression. You have to have a balance. And what we are doing here today is arbitrary, excessive, disproportionately invades the right of free speech. If this law goes through, to cite what has been stated, it will have a chilling effect on free speech. Madam Speaker, if we look at the explanatory memorandum, paragraph 3b says that the various enactments are being amended to inter alia, bring improvement to the Information and Communication Technologies Act. I'm afraid, Madam Speaker, we are not bringing any improvement. In fact, we are going to enact, if this bill is passed, we're going to come up with a law which is extremely dangerous and is going to cause a lot of distress, unwarranted distress on the population. Madam Speaker, turning quickly to the other provisions of the bill. Again, I don't think, unfortunately, that the ICTA is the only place which may be construed as being anti-constitutional. If we look at the letters of request rule of 1985, this is section 12. Section 12 of the bill. The letters of request rules 1985 are being amended. Now, what is this letters of request rules? It is not an act of parliament, Madam Speaker. What it is, it's a set of rules that was made by judges of the Supreme Court under Section 198 of the Courts Act. So there is a Courts Act. The Courts Act gives a power to the Supreme Court to enact laws. And among these laws, the Supreme Court, the judges had enacted the letters of request rules. Now, this is the power which has been given to the judiciary to make rules. And the Courts Act, Section 198, subsection 3b, provides rules made under subsection 1 may provide for the means by which particular facts may be proved and the mode in which evidence may be given in civil cases before any court. So the law, the Courts Act already give the power to the judges to come up with rules. Because we're talking about the judiciary. We're talking about separation of power. We have the executive. We have parliament who makes laws. But we have a judiciary who interprets and provides sentences. And the judiciary, in its realm, they want to be able to make their rules, how to prove something, how to adduce evidence. If someone is not in Mauritius, is outside of Mauritius and he wants to deport, it is for the judges to decide what type of rules, what do they accept or what not to accept. The judges. And the judges has passed a rule. And today we, Parliament, legislature, we're going to interfere with the powers of the judiciary which we have given to them. We are now going to amend rules which was done by the judges. Isn't that an infringement on the role, powers of the judiciary? Now Parliament is going to interact, infringe what... I'm talking about rules made by judges. Judges made the rules. Now by Parliament we're amending laws, rules made by judges. We're not amending laws passed by us. We're amending laws made by, rules made by judges. Is that proper? So that's for the form. Now on the substance. What is this rule that is being amended provide for? It provides that where in relation to any proceedings other than criminal proceedings pending before a court in Mauritius, the Attorney General considers it desirable to obtain the evidence of a witness in another state, he may make written requests to the central authority of that state to have evidence taken or document or other articles produced, and to transmit to Mauritius any evidence, document, or article taken or produced. So first of all, it is the Attorney General. It is the Attorney General who considers it desirable to obtain. So it is he who will decide. As at today, if a foreigner wants to obtain evidence in Mauritius, he has to go through the master. The master is an independent judicial officer. His independence is protected by the Constitution. Today, we're going to give this power to the Attorney General. And let me remind honourable members, the Attorney General is a political appointee. It is the only minister who, by virtue of the Constitution, can be someone who is not a member of Parliament. He's purely and simply a political appointee. And until recently, Honourable Eric Gadou, who was Attorney General, was not a member of Parliament. So we're talking giving powers to a political appointee. If he considered it desirable, he's going to make a written request to the central authority. Central authority with capital C, capital A. And of course, this is not defined. What is central authority is not defined in the Act, in the letters of request rules, or in the Courts Act. So let us sit down and think what we're saying. There is a civil case, a dispute, a divorce. And one of the parties is outside of Mauritius. And the Mauritian party wants to take evidence from that person who is no longer in Mauritius. He doesn't have to go to court. He has to go to the Attorney General. Hey, can you please consider writing the competent authorities, your friend, and telling them to go and take deposition from my former husband? This is what he's saying. There's absolutely no criteria, no objective criteria. It's purely at the discretion of the Attorney General. If he considers it necessary, he will contact the competent authorities and get the proof. So every private party, every private dispute where there is a non-citizen, a non-resident in Mauritius, if we want to secure evidence, we will have to go through the Attorney General. In a dispute between two private citizens, we'll need to have the Attorney General determine whether he will contact his counterpart in a different country and allow us to take evidence. And the risk of conflict of interest. What happens if there's a case involving the state? What happens if there is a case involving the Attorney General? Is that far-fetched? Have we all forgotten what happened 2 years ago? The famous Free Jew scandal? The affidavit sworn by a non-Mauritian, non-citizen who said that he was sequestrated in a house, citing the former Attorney General, the former Minister of Good Governance, and the actual Prime Minister. If there is a case, a civil case, a commercial case following from this affidavit, it is the Attorney General who is going to decide whether to go abroad and get evidence. Isn't that a clear case of interference by the executive in what should be the judiciary role? I don't have any problem when it comes to criminal matters. Criminal matters, there's already, under mutual assistance in criminal matters, the power is already given to the Attorney General to go and make requests. And we see he's done that in the Boscalis case recently. I don't have any problem. But we're talking about criminal matter. Criminal matter, they need to have one authority to contact his counterpart. But for civil and commercial matters, there's a private dispute. Attorney General has absolutely nothing to do with a private dispute between two individuals. So it should not, I respectfully submit, it should not be the Attorney General who has to make the request. It should come from either judging chambers or a master's, or even if it is the Attorney General who ultimately sends the request, it should be the Attorney General upon being directed by a judge of the Supreme Court. At least then, you know, I'm a private party, I want to take evidence because a witness cannot travel to Mauritius. I want to be able to take his testimony outside of Mauritius. I get leave from the court. The judge then informs the Attorney General, and the Attorney General writes. I won't have any qualms with that, because I would have had the protection of a judge. But as it is now, it is the Attorney General, if he considers it desirable, he's the one who's going to decide. So, Madam Speaker, this is extremely dangerous, and as I said, for me, it infringes on the separation of powers and on the right of the judiciary. The next point that I have a problem with, Madam Speaker, is with this tendency of this government and of the Attorney General to try to interfere, try to control decision-making. You know, what others have coined dérive totalitaire, the obsession of the government and the Attorney General to control everything. 2 weeks ago, Madam Speaker, when we debated the law on acquisitive prescription, I found it very odd that the Honourable Attorney General stated that he had requested the Law Reform Commission to send him a report in confidence, confidential, so people should not know what the Law Reform Commission has to say. And a few days before that, the Law Reform Commission published a paper. And in this paper about fake news, a report on fake news. And what did they say in that report? They said that we have been requested by the Attorney General to prepare a paper on social media, fake profile, fake news, and other harmful digital communication. And what did they do? They prepared a report which was not to the taste of the government of the day, because that report stated that we cannot criminalize fake news because we'll be infringing on freedom of expression. They considered Section 46. They said, yes, we can amend it for moral harassment, but not for fake news. And today, we are amending Section 46 without taking into consideration what Law Reform Commission has stated. The truth of the matter, Madam Speaker, is that today, the Attorney General is not happy with the report and opinion that is being published by the Law Reform Commission. The Honourable Attorney General and perhaps the government wants to control and get sanction to control the Law Reform Commission so that the Law Reform Commission would sanction whatever they decide. And this argument about, a term of office for 5 years is too long because when you are representing the Bar Council or Law Society and there's a change at the level of the Bar Council and Law Society, there should be a change of its representative. If that was true, if that was the reason, then give that power to the Bar Council and Law Reform Society. Why give that power to the Attorney General? Why is it that it is the Attorney General who would remove these people? Why? And at the moment, they can only remove these people if they have been bankrupt, neglect of duty, misbehavior, physical or mental incapacity. Because it is important to ensure the independence of the Law Reform Commission. Now, imagine, someone probably close to power, because I don't see many distinguished people accepting to be under the control of the Attorney General for 2 years. Now, imagine someone who, sits on this Law Reform Commission, has been appointed by the Attorney General or by another person. He knows that any time the Attorney General is going to remove him or her, do you think that this person is going to write anything which is contrary to what the Attorney General is expecting? Is it how we are going to guarantee the law reform, the independence of the Law Reform Commission? The Honourable Attorney General mentioned Mr. Ramdewar. Well, I have a lot of respect for him because he was also my teacher when I was doing the bar in Mauritius. But Mr. Ramdewar is one of several members of that Law Reform Commission. And what did another person, another member say in the newspaper, Mr. Narsinghen? C'est une atteinte à la démocratie. L'indépendance de la Law Reform Commission est menacée. So, it's not because one person is saying that we are agreed that automatically the Law Commission should fall within the purview and supervision of the Attorney General. Madam Speaker, this control of the Attorney General is also there when it comes to the amendment, the proposed amendment to the IGLS. The IGLS who forms a very important functions in Mauritius because they are the one who is responsible for admission to the bar for training. And I have no problem with the first amendment proposed by the Attorney General to compel them to make guidance rules. I have no problem, and in fact, I think it's long overdue. So that is Section 6. But where I do have a problem is in Section 17. Section 17, for the time being, provides that the board of the Institute of Judicial and Legal Studies can make regulations after consultation with the Chief Justice. And now this is being amended to provide that it is not the Chief Justice who is going to supervise or control the IGLS, it is the Attorney General. So when the IGLS is going to make proposition about sentencing, guidelines, about damages, it's not the Chief Justice who has to concur with what they're saying. It is the Honourable Attorney General. Again, a mainmise de l'Attorney General sur the Institute for Judicial and Legal Studies Act. Madam Speaker, I have spoken lengthily on this bill because I think what we're doing is really anti-constitutional. And I will end by citing what was said in another case of the Indian Supreme Court. In August 2016, following a series of cases lodged by Mrs. Honorable Jayalalalitha, who was then Chief Minister of Tamil Nadu, and other members of her party, against political opponents. And they were all arrested under this Information Technologies Act, which was then declared anti-constitutional. And this is what the learned judge said. This is not how a healthy democracy functions. You must face criticism if you are a public figure. So we are all public figures. Let's behave like grown-ups and not come up with laws that are anti-constitutional. Thank you.